Trump New York civil fraud trial closing arguments. New York AG office closing arguments. In a dramatic turn, Donald Trump transformed the New York civil fraud trial's closing arguments into a campaign-style event, delivering impassioned speeches both inside and outside the courtroom. The $370 million trial, brought by New York Attorney General Letitia James, poses a significant threat to Trump's business and brand, potentially barring him from conducting business in the state. Trump's decision to seize the opportunity to address the court directly reflects the gravity of the situation and underscores his eagerness to leverage the trial for political purposes as he contemplates a run for the presidency. Judge Arthur Engoron, who has already found Trump liable for fraud, is set to issue a comprehensive decision by the end of the month. The trial's conclusion leaves lingering anticipation for the court's ruling, expected by January 31st. Here are the key takeaways from the second part of the closing arguments. Judge rebukes Trump's closing statements, not how this should have been done. Judge Arthur Engoron expressed disapproval of Trump's closing statement, stating, "This is not how this should have been done," just moments before Trump began his statement. Despite attempts to control Trump's narrative, the former president criticized state attorneys as disgraceful and labeled the statute used against him as vicious. Trump reiterated his lawyer's claims, asserting that he is the sole victim of fraud in the case. Trump further directed criticism at Judge Engoron, claiming the judge refused to listen to him, stating, "You can't listen for 1 minute." As Trump continued his assertions of innocence, Judge Engoron intervened, instructing Trump's attorney, Chris Kise, to control his client. "Mr. Kise, please control your client," Engoron said, expressing his embarrassment. However, Trump persisted, proclaiming, "I did nothing wrong. They should pay me for what we had to go through." Additionally, he accused New York Attorney General Letitia James of suing him for publicity. Engoron, signaling the end of Trump's allotted time, held up his phone screen to signal to Trump that Trump had run out of time and subsequently called for a break. Trump acted with intent to defraud, according to AG lawyers. During the closing presentation, the Attorney General's office maintained a firm stance, asserting that Donald Trump acted with intent to fraudulently inflate the value of his assets in financial statements. Attorney Andrew Ammer underscored Trump's central role, declaring, "The buck stopped with him," and emphasized Trump's responsibility for the actions of Trump Organization executives in manipulating asset values. Ammer argued that Trump's active involvement in reviewing and approving the statements should lead the court to infer that he acted with intent to defraud based on his extensive knowledge about these assets. The Attorney General's office is pursuing a $370 million claim against Trump, alleging that his deceptive financial statements enabled him to secure loans and insurance at more favorable rates. The Attorney General's reliance on Michael Cohen's testimony added a significant dimension to the case, as Cohen asserted that Trump instructed him and Alan Weisselberg to reverse engineer financial statements. While Cohen's testimony initially suggested intent to defraud, he later nuanced his statements under cross-examination, claiming Trump did not explicitly direct him to inflate the numbers. In response, Cohen clarified, "He tells you what he wants without specifically telling you. We understood what he wanted." Trump's defense, however, vigorously attacked Cohen's credibility, branding him a serial liar and challenging his reliability as the sole witness, alleging an intent to defraud during the closing presentation. State attorney decries lack of substance in Trump's defense closing. In a scathing critique of Trump's defense, State Attorney Kevin Wallace asserted, "We're back to hearing the same arguments." Wallace highlighted the absence of new information from the defense, stating, "Donald Trump is rich, banks like rich people," and criticizing the defense for not presenting any novel facts. He pointed out that the defense failed to argue that the alleged fraud was a mistake, except for the overvaluation of the Trump Tower penthouse, and they did not contend that the numbers on Trump's financial statements were accurate. According to Wallace, a comprehensive examination across time reveals that fraud was central to the Trump Organization's business operations. Wallace specifically targeted the credibility of the defense's expert witnesses, labeling them a murderer's row of experts collectively paid at least $2.5 million by Trump. He asserted that none of these experts provided evidence beneficial to the court as a fact-finder. The tension escalated when defense attorney Chris Kise objected to Wallace's characterization, calling it outrageous. In a humorous retort, Wallace clarified that he was referring to the 1927 Yankees, emphasizing the lack of substance in the defense's presentation. Trump's accountability, state attorneys argue cash crunch drove fraud. State Attorney Andrew Ammer emphasized Donald Trump's responsibility for his company's actions during the Trump Organization civil fraud trial, declaring, "The buck stopped with him." Ammer held Trump accountable for the alleged conduct between 2011 and 2015, asserting, "He was responsible for all the conduct I just reviewed." Ammer questioned why Trump's lawyers never challenged former lawyer Michael Cohen's testimony, where Cohen claimed Trump instructed him and Alan Weisselberg to reverse engineer financial statements. Amr argued that the court should infer Trump's involvement based on the defense's decision not to question Trump on this crucial point. Additionally, Amr highlighted Eric Trump's alleged inconsistency in testifying about his knowledge of his father's financial statement, contending that both Trump's sons were aware and complicit in the schemes to defraud. In a separate argument, State Attorney Kevin Wallace introduced a new theory, claiming that a cash crunch driven by the costs of Trump's 2016 presidential campaign and business obligations motivated the alleged fraud. Wallace asserted that the Trump Organization's fraudulent activities saved hundreds of millions of dollars, allowing the company to endure a financial crisis during the 2010s. According to Wallace, the significant expenses for property renovations, including golf courses and the old post office building, created a financial strain by 2017. Facing potential negative cash flow, Wallace argued that the company resorted to fraud. Wallace stated the defense failed to establish that any of the alleged fraud was a mistake, other than the overvaluation of the Trump Tower penthouse, and that the defense did not argue the numbers used by Trump on his statements of financial condition were precise. If you look at it across time, it becomes clear that fraud was central to the operation of the Trump Organization's business, Wallace uttered. Despite objections from Trump's attorney Chris Kise, Wallace passionately defended his theory, asserting its relevance and prompting a heated exchange. By the time you get to 2017, Mr. Trump was becoming president, and the company was getting low on cash, Wallace stated. Confronted with the opportunity of a negative income, the organization picked to embrace misrepresentation, as per Wallace. Judge Engoron expressed skepticism but allowed the presentation to proceed. Engoron expresses doubts over Trump's son's knowledge of fraud. The NYAG's office has stated the former president, his sons and the ex-CFO, all bear some culpability for the financial misstatements in the organization's statement of financial considerations. What this trial is about is, what did the defendants know, when did they know it, and did they act as a conspiracy? New York AG lawyer Kevin Wallace stated in closing arguments. The answer to the latter question is yes, he concluded. Judge Arthur Engoron interrupted during both the Trump's defense and the AG office's presentations to ask questions, expressing skepticism about several facts. He displayed skepticism regarding the level of knowledge Donald Trump's adult sons, Eric Trump and Donald Trump Jr., had about potential fraud within the organization. In response to questions about Alan Weisselberg's $2 million bonus, which followed his admission and conviction of financial crimes, AG lawyer Kevin Wallace responded to the suspicion, stating that someone would have committed, admitted and been convicted of financial crimes and then get a $2 million bonus is suspicious. Engoron further pressed the Attorney General's office on the evidence supporting the liability of Eric Trump and Donald Trump Jr. for fraud, questioning, "What evidence do you have? That they knew that there was fraud?" The judge remained unconvinced, especially concerning Donald Trump Jr.'s awareness of fraud. Engoron challenged assertions from both the plaintiff and the defendants, raising questions during their presentations. When Trump's lawyer, Chris Kise, cited testimony from NYU accounting professor Eli Bartov, who claimed no material misstatements in Trump's financial statements, Engoron expressed skepticism, stating, "I didn't lend much credence to Mr. Bartov." The judge engaged in a debate with Kise over whether Trump's financial statements contained material differences, particularly challenging Kise's argument that Deutsche Bank's lending decisions should be viewed through the lens of the bank. Engoron disagreed, emphasizing the importance of distinguishing between a bank and the bank, showcasing his thorough scrutiny throughout the trial. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.